Hello, thank you all for attending this morning, or this afternoon now. Today's presentation from NB Migration Law will be on partner visa applications with red flags and how to strengthen high-risk cases. I'll be the presenting for you today, and EJ from our customer relations team will be assisting throughout the presentation as well. Firstly, can everyone hear me? Can you please react with a thumbs up or type a message in the chat if you can hear, so that we know we're on track. Okay, that's good. Glad to know the technology is working. So just a brief overview of about ourselves, and our firm is NB Migration Law. We operate within No Borders Law Group. Other service offerings of No Borders Law Group include commercial, employment, and property law, and we've been in operation for over 27 years. So the key discussion points for today will firstly be an overview of the partner visa options and visa pathways within the family migration stream for partners. Next, we'll be giving some examples of documents you can consider including for a strong application. And then finally, we'll be going in red flags to avoid and situations to be aware of that may be more complex than your ordinary application. Firstly, partner visa options vary depending on the status of your sponsor. So if your sponsor is an Australian citizen or Australian permanent resident or an eligible New Zealand citizen, all the standard partner visa options are available to you. If they're a temporary resident, for example, a student visa holder or a 482 visa holder, then you're more likely to be looking at a subsequent entrant pathway rather than a partner visa or prospective marriage visa pathway. The most complicated of these three, Australian citizens will know that they're an Australian citizen. The same generally goes for permanent residents, is eligible New Zealand citizens. Eligible New Zealand citizens are only New Zealand citizens who were in Australia on the 26th of February 2001 or for at least 365 days in the 2 years prior to that date. So they'll consider those people as resident in Australia on that date. For eligible New Zealand citizens, they get treated as Australian permanent residents under the migration system for partner visas. For the other New Zealand citizens who aren't eligible New Zealand citizens, the main partner visa option for their partners, if they move to Australia and are living in Australia on a 461, is a 461 visa for if they're living here on a 444. The 461 is a New Zealand family relation visa. It doesn't offer permanent residency or a permanent residency pathway in itself, unlike the partner visa options. Going through these, onshore partner visa is the most common. That's if you apply while your partner is in Australia, living in Australia with you. The next is an offshore partner visa. That's most common for expatriate Australian workers. For example, an expatriate Australian worker living in Singapore with a partner from Singapore who isn't immediately looking to move to Australia until their partner's visa is granted would most likely be looking at an offshore partner visa. And then a prospective marriage visa is where you're not quite living together full time yet, but you're intending to enter into a married relationship. So it has a lower relationship threshold than the subclass 309 or subclass 820. It's assessed more leniently because it's generally for long distance partners who have met. For example, a common circumstance where subclass 300 may be a better option than the 309 or 820 is if you've met your partner overseas, staying local, we'll use Indonesia, being a neighboring country. So if, for example, someone's met a partner in Indonesia, they're in a long distance relationship, they've met in person a couple of times, but they don't live together full time, then the prospective marriage visa is the most fitting and applicable subclass for that application, especially if a visitor visa can't be obtained. The 801 and 100 are the permanent visas in the program. On an initial application, if the relationship's not long term, the 801 or 100 are not going to be granted on that first application. Long-term relationships are those over 3 years or over 2 years with children. That's just something to keep in mind because sometimes people think the permanent partner visa is going to be granted on the initial application. It's not unless you have that long-term relationship or long-term relationship with children. Other key considerations, as it is in the name, the onshore partner visa, you have to be in Australia when you apply for it. The offshore partner visa, you have to be outside Australia when you apply for it. The prospective marriage visa fits in here as well. You have to be outside Australia when applying. It's actually been changed. The slides just need to be updated. Apologies. You do not need to be offshore when the 309. Yeah, you can be onshore or offshore for the 820 to be granted. Providing the same goes for the 309 generally. So for example, if your partner's just in Australia visiting, they're not going to tell them to fly overseas before they can grant the 309 now. They updated that in the last couple, relatively recently. Yeah, other benefits of the 820. 820 is our preferred one to apply for is an onshore partner visa because your partner can get full-time work rights in Australia on a bridging visa while waiting for an 820, and they can also access Medicare while awaiting the 820. So there are lots of benefits to the 820 even before the visa is granted, whereas the 309 and 300, there's limited benefit until after the visa gets granted. Going into the different types of relationships assessed under the partner visa program, there's two main ones. Spousal relationships are married relationships. It's if the marriage is a legal marriage, it'll be assessed under the spousal criteria. Religious marriages that aren't recognized by law will not fall under spousal relationships. The important aspect is legal recognition. De facto relationships are very different from girlfriend boyfriend relationships or just dating. You need to be living, think of it, living as if you were in a married relationship. So living together full time, sharing finances, sharing social groups, and having that commitment to a shared life together. There's additional requirements for de facto relationships as well. If a de facto relationship, it needs to be at least 12 months. That does not apply to spousal relationships, so that's a consideration. The 12 months can be waived in certain states and territories by registering your relationship. That's the most common way to waive the 12-month criteria for a de facto relationship. Almost all the eastern states have relationship registration available so that you can register your relationship in the state, and that waives the 12-month requirement for a de facto relationship. The only states it's not available in are Western Australia and the Northern Territory. If you're in Western Australia or the Northern Territory, it's a lot stricter where you either need to be in a 12-month de facto relationship or a spousal relationship. There are other waivers to the 12-month criteria, but they're quite challenging to meet. They involve compelling and compassionate circumstances. The most common is an Australian citizen child at the time of applying for the visa. Departmental policy is that pregnancy alone in of itself isn't enough to meet compelling and compassionate reasons to waive the 12 months. Okay, going to our next slide. There are 4 elements considered. We touched on them briefly before. These are how relationships are assessed under the Act as to whether it is actually a spousal relationship or a de facto relationship. The reason they look at these elements is to make sure it's not just a paper marriage or a paper relationship registration, and that the partners are actually living together as partners. The first element they consider, or one of the main elements, is the financial aspect. So are you sharing finances as partners in your relationship. The most common way people will show this is through joint account statements where they hold bank accounts in both names. Alternative or supplementary forms can include joint utilities payments, joint purchases or receipts. For example, if you purchase a house together, that's obviously a significant financial investment decision that's been made by the two of you as partners. Something to keep in mind is it can also include binding financial agreements. Because that shows how you've set up your arrangement for the financial aspect of your relationship. That's a general asset protection measure that can be taken and considered by sponsoring partners if there's a discrepancy in economic situation between the two partners applying for the visa. Some other ones, if you aren't confident in the relationship or wanting to open the joint accounts and wanting to stay relatively independent financially, that's okay. But you need to make sure you have the transfers between the two of you documented. Different people document their finances in different ways. It's just important you show the sharing. Going to the nature of household, this is the key reason we don't recommend generally that long distance relationships go through the 309-100 because the department wants to see that you're sharing household responsibilities between the two of you. The most common is a joint tenancy agreement. Joint property ownership is rarer due to the Foreign Investment Review Board for joint property purchases and additional fees paid. So if one partner owns a property, that's usually when this element becomes harder to show, is when the Australian partner owns a property, because there's additional costs involved to get a non-Australian citizen or permanent resident partner onto title. In such situations, mail to that property address for both partners can be used to show that the partners are living together. Having a driver's license for that address and making sure all your legal documentation is also tied to that address as the partner, along with property ownership from the other partner. In that way, you can demonstrate to the department that you're living together. The department also likes to see explanation if you spent time long distance, especially for the household element, so that you can show you're still sharing your household. It's a lot more technical at this point and can involve things such as shared calendars, routines, set times for example, watching Netflix together or joint care of children. But it gets a lot more complicated, and that's a general red flag. If the partners aren't physically living together, the department will very strictly look at the household element. Next is social. Most people that apply for partner visas have relatively strong social evidence. The social evidence generally consists of photos together. It's important that these aren't just selfies, but you also have some group photos when applying for the application to show that your family and friends are aware of and support your relationship and you're not just hiding it. For example, if it's only selfies, they may be concerned that your family and friends don't actually know of the relationship. Invitations issued jointly to the two of you for social events such as birthdays, Christmas parties, weddings, work events, they can also be used to show the social recognition of you and your partner's relationship, as can joint travel itineraries. A key aspect of the social element is you need to get two statements in the form of a Form 888 to support your application. If applying in Australia, they must be from Australian citizens or permanent residents. Those statements attest to your relationship. Generally, people are quite strong on the social aspects of the relationship. Issues can arise or limitations when partners are living in a country or remote area far away from people, or there's a disconnection from family, or they're not very social, or non-family approval of the relationship. in those cases, usually work references or friends references are the alternative pivot in such scenarios. Moving next to commitment. Commitment is our fourth element. It's the fourth of the pillars to demonstrate. The most common commitment evidence for a spousal relationship is the marriage certificate. So the legal marriage certificate in itself is very strong commitment evidence for the relationship. For registered relationships, that relationship registration is also very strong commitment evidence. Again, these elements somewhat intertwined. So we mentioned already communication, if not physically together, that also goes to the commitment evidence. So lots of things can cover multiple aspects of the relationship criteria. Again, going back to our example of a joint purchase, so a joint car purchase, it can go to financial because it's a joint purchase. It can go to social because you've represented to the car dealership that you're in a relationship, and it can go to household if it's your means of transportation for your household. So just keep in mind that the same evidence can actually cover multiple aspects within these criteria. Statutory declarations are the last one that I want to touch on. They primarily go to commitment, but cover all four elements, and you should make sure to cover all four elements in statutory declarations. Each partner should provide a statutory declaration in the application. That's what we strongly recommend because it gives the department insight into your relationship rather than just seeing a bunch of documents as to how you actually live as partners, how you met, how your relationship developed, and your future plans and commitment moving forward into the future together. Okay. Preparing strong evidence. I believe we have covered this. It's mentioned there, the Form 888s are quite important for the social element so that you have those declarations supporting your relationship from fellow Australians. One thing to note on Form 888s, obviously there is some leniency for if you're living outside Australia on a permanent basis and are applying for an offshore visa, they still want two Form 888s. But going back to our example of living in Singapore, it could be from Singaporeans. If you and your partner have lived in Singapore for the whole duration of your relationship, it's not expected that you'll have two Australians necessarily. Moving forward into some red flags and things to avoid in an application. Partner visa applications, yes, it's what you show, but it is also not showing the wrong things or giving them reasons to refuse your application. So you need to give them reasons to grant the application, but you also need to make sure you don't give the department reasons to refuse the application. One can be inconsistent evidence because that would undermine your credibility and mean that they don't necessarily give as much weight to the evidence you're providing. Inconsistent evidence can occur if between the sponsorship application and the visa application, there's different timelines, different address dates. The statements have different series of events. This can raise red flags with the department. One key concern of mine with inconsistent evidence, and when we I'd say most regularly see inconsistent evidence, is when people use generative AI for relationship statements. When partners use generative AI for relationship statements and don't write them themselves, the AI can add some stuff that didn't necessarily occur in the relationship. And if it's not reviewed carefully, it can create inconsistencies across an applicant and a sponsor's relationship statement. So if using AI to help draft a statement, you need to be very careful that the statement is still entirely fact-based and nothing made up was added to the statement. Yeah, it's also quite easy to read from the style of writing when stuff is AI. And if we can read it, the department can also likely read it as well. So that's a new evolving red flag over the last year or two, is the increased use of AI. And the department doesn't view it favorably when you're providing AI generated documents to them. Insufficient proof of cohabitation. This is one of the key differentiators in the department's eyes between a de facto relationship and a girlfriend-boyfriend relationship is if the partners aren't yet living together, the department's much more likely to see it as just being a girlfriend-boyfriend relationship and not yet having progressed to the level of a shared household and shared financial resources, especially for long distance relationships. Apologies. Yeah, the lack of shared finances also goes to that in considering whether it's a girlfriend-boyfriend relationship or a de facto relationship in the department's assessment. Going on to the next one is missing translations or certified copies. This is usually a slightly lower issue. It can delay processing. The department for partner visas will usually issue Section 56 requests for more information if a translation's just missing a certification that has been provided. They're not going to refuse the application on it, but it can slow your processing down by the department needing to request their official translations and going through that process later on. And when they request further information, your application can go back to the back of or later position in the queue when it could have just been granted on the day they issue that Section 56 request if all the translations had been provided with the application. Underestimating processing times is another one. The processing times we estimate are always based on the government's official website. It's disclosed on Department of Home Affairs, the median and standard processing times. The department considers standard processing times those in which 90% of applications are finalized. Median processing times when the average or median application is finalized. So 50% are finalized before that date, 50% are finalized after. These have been ballooning over the last 4 years to be nice to the government. Yeah, it wasn't long ago, even 2022, 2023, that these were comfortably under a year, well under a year for median processing times for that 820 and 309, and even standard processing times, while slightly longer, weren't egregiously long as they are getting now. Just for some examples, the 820's new median processing time that was released on the 6th of March is now 18 months, and the standard processing time, so 90% of applications, is 31 months. That's 2.5 years for an 820 to process. Sometimes people can panic if no decision's been reached yet. It happens. The processing times are slow. Also, offshore partner visas, if people have made arrangements to immediately move to Australia within 6 months of applying for the visa, that's probably unrealistic nowadays with the 309 because the 309's median processing times are now 16 months and standard processing's up to 24 months for 90% of 309 applications to be finalised. Even the 300, it's now 11 months as the median processing and 2 years as the extended standard processing time frame for a prospective marriage visa. So you can book your wedding, but just be flexible as to your date of the wedding if you're applying for a prospective marriage visa, because processing times can interrupt plans. And it is important to be aware of them beforehand to make sure it doesn't put strain on the relationship if there's an unreasonable expectation as to the time frame for moving to Australia or other life plans like employment in Australia. Next one is overlooking bridging visa rights. Sometimes people aren't aware of what they can get on the bridging visa for an 820. The most common example is Medicare. It's the main benefit, I guess, of the bridging visa A, once on the bridging visa A with work rights and having applied for an 820, since that 820 is technically a joint application for an 801, even if the relationship's not long term, your partner can access Medicare. So that's a significant cost saving, especially in the current economy on health insurance, if your partner can access Medicare while awaiting the outcome of their application for an onshore 820. Other ones are even if your partner arrives on a visitor visa and then applies for the partner visa in Australia, after their 3-month visitor visa expires, they'll transition to having full work and study rights in Australia on the bridging visa while they wait for the partner visa. That's unlike most other visas where the bridging visa carries the conditions of the previous held visa. So there are some strong benefits for an onshore application, regardless of the last visa held by your partner. Some potential complicated situations are if there's a relationship breakdown during processing. No one plans on this when they apply for the visa. If the relationship ends, it can lead to visa refusal. There are some limited exceptions. For example, if there's shared care of children or domestic violence occurs or the sponsor passes away, and that's why the relationship ends. So there's some limited exceptions in relationship breakdowns. If your relationship does break down and you're a visa applicant, it's strongly recommended to get legal advice as soon as possible. Your visa isn't instantly going to be refused, but if you don't take action, it will likely be. The other one is domestic violence. The department doesn't want to force visa applicants to stay in relationships where domestic violence is occurring. It would be quite a bad look for the government if they were doing that to achieve a visa outcome. So they do have some pathways for people experiencing domestic violence while awaiting a partner visa outcome. Again, strongly recommend seeking tailored legal advice to your situation if you experience that while awaiting a partner visa outcome. Going to the next one, previous sponsorships or partner visas. This is just a limitation and something to be aware of for sponsors. If you've sponsored a partner within the last 5 years, they've applied for a partner visa as the sponsor, then you can't sponsor someone else again for 5 years. So if hypothetically person A and person B are in a relationship, person A is Australian, person B is the non-Australian, person A sponsors and person B applies for the visa today. Person A then can't sponsor another person until after 18th of March 2031 because it's from the date person B applies for the visa. The same goes for person B. It's not about the date of grant, it's about the date the visa is applied for. So person B, if they apply for the partner visa today, they can't sponsor anyone else for at least 5 years. Other sponsorship limitations are if you've sponsored twice previously. There are exceptions to this for compelling and compassionate reasons. Again, most commonly, this is the interests of Australian children. The other main sponsorship limitation is there's a maximum of 2 sponsorships for any person in their lifetime. You can only sponsor twice. They don't want people repeatedly sponsoring people every couple of years for obvious reasons. And the government's decided to set the cap at 2 for whatever reason. If there is a third relationship and there's compelling and compassionate reasons, then it can be applied for. This is unfortunately rising as an issue. Moving to our next one, divorce or separation from a previous partner having not occurred. There are circumstances where it's a relatively non-issue. For example, partners separated 10 years ago, but just haven't legally finalized a divorce. Make sure to finalize the divorce during processing because otherwise it'll be very closely scrutinized, the application by the government, if in the family law records, you're still showing up as married to a different person and you're still in a legal marriage to someone else, it makes it unnecessarily difficult for the new partner visa, and it also eliminates eligibility for the prospective marriage visa because you can't marry again if you're still in your old marriage. Yeah, so it's important to just make sure the divorce is finalized. If it was a de facto relationship you're in previously and it's been declared to the government, you need to show the separation. Most common issues here are potentially someone was granted a temporary visa with a previous partner and forgot to update records prior to the visa being granted, and someone got a secondary visa. Then they need to be careful of the relationship dates when applying for a new partner visa, independently of that. Yes, contradictory information. Again, as we discussed, we don't want to undermine our credibility when applying for a partner visa. Yeah, if you undermine your credibility with the department, it makes everything significantly harder because they don't trust anything that you provide to them. With children, children need consent. So, for example, if you're sponsoring someone from a country and they have a child with a former partner in that country, you'd naturally need consent of their partner or be able to show that they have sole custody of that child, as then the government's not going to let that child move to Australia unless the other parent, if the other parent still has shared custody, consents to it and allows it. Character or health concerns these can significantly impact applications. If a sponsor or visa applicant has a criminal record, it will depend on the type of offences and the punishment for the offences. It can also be matters such as DVOs that could be considered regarding the general character of a sponsor or visa applicant. Health issues relate to visa applicants, they're not applicable to sponsors. Health issues for a visa applicant, again, there are certain circumstances where health waivers will be required if it's a communicable disease or something that would incur significant costs. Yeah, next one, visa status or bridging visa status. It's strongly recommended to apply from a substantive visa rather than a bridging visa. If you apply from a bridging visa, you need to show compelling and compassionate reasons to allow you to apply from the bridging visa within Australia. That applies even if it's a bridging visa A. Some people applying think the bridging visa A doesn't need compelling and compassionate reasons. It does still need such reasons. Yeah, overstaying a visa before applying. So if you're in Australia without a valid visa, that also makes it more complex because you're not holding a visa when applying. And then that no further stay condition is key. If you're, for example, on Australia on a visitor visa without no further stay, the application can't be done as a result or until that no further stay condition gets waived from the visa. So you need a no further stay waiver before you can apply, and no further stay waivers are very rarely approved because in that visitor visa application, there would have been reasons given for returning to the home country or your partner's country. That's all for now. Unless anyone has any questions, we're going to open it up to a Q&A space. If nobody has any questions, we'll wrap up now. We do have free consultations available. Okay. Yes, it is harder, to put it bluntly, Remy. It is more challenging if they have a visa refusal or a pending ART application. Yeah, so the ART depends where they're at in the process. If they've had the visa refused and they're awaiting the ART, it does get more complicated. Some common options are going through Reme. First, an onshore partner visa application following the refusal. If your partner had that refusal in Australia before they've applied for the ART, there'll also be a Section 48 bar in place. So you'll need to make sure that your Form 888s also have statutory declarations supporting the application as well, and covering that you and your partner are in a genuine and continuing relationship. An alternative option is if your partner has a bridging visa A, you can apply for a bridging visa B for them. They can then travel out of Australia and re-enter on that bridging visa B. While they're out of Australia on the bridging visa B, you can apply for an offshore partner visa. The benefit of that is you avoid having to show compelling and compassionate reasons, which are a relatively high threshold. So you can avoid that if they apply for the offshore partner visa while overseas on a bridging visa B. They re-enter Australia on the bridging visa B and stay in Australia until their ART or court hearing. I'm going to John. If someone was on a tourist visa and applied for a student visa and is now on a bridging visa. So if they applied while they were still holding the tourist visa for the student visa, not quite sure regarding when, depending on the timing of this, assuming they've done what's been said and they applied for the student visa from the tourist visa in Australia and are on a bridging visa A, then you need to show compelling and compassionate reasons because it becomes a Schedule 3 application, since the bridging visa is not considered a substantive visa like the tourist visa and student visa are. Yeah, I'd have a couple of questions for your partner though to make sure regarding the time. Okay, student visas rejected. That makes more sense because they've closed the student visa to tourist visa holders onshore. Bridging visa A, you've got two options here, John. The first is if there are compelling and compassionate circumstances, you can apply for the partner visa in Australia, the 820 onshore. Similar to what we discussed with Reme, you'd need to show compelling and compassionate reasons for the onshore partner visa application. Alternatively, John, your partner can travel outside Australia, apply for a bridging visa B. The bridging visa A will have a no travel condition. With the bridging visa B, once it's granted, your partner can travel outside of Australia, apply for the partner visa while outside Australia, potentially also complete biometrics if they're requested while outside, then return on the bridging visa B, live with you in Australia up until the ART hearing and get through as much of that offshore processing as possible prior to the ART hearing. But yeah, it'll be very specific to your relationship. This is general advice, not specific legal advice to your personal situation, not knowing every single fact involved with the case. Okay. Yeah. If that's all for questions, yeah, we do have free consultations available as a firm. It's just to provide some initial advice regarding someone's situation, regarding the pathways and options available to them, and to make sure that we can help guide you on the right path to achieve a successful migration outcome. The QR code's on screen. If you have a phone, you can scan it. Alternatively, you can message the customer care. I believe they can put their email for themselves in the chat. Oh, yeah, the customer care email's in the chat, so you can also email them to arrange a consultation if that's something of interest. Yeah. Now moving to our upcoming webinars, they are quite different topics. The first will be on childcare professionals visa options, employer sponsorship and workplace strategies for childcare centres. We'll be going into designated area migration agreements in that as well, I expect, for childcare services. The next one is aged care, healthcare, and community worker professionals. So the visa pathways and migration strategies for people in these fields. That's all for today. Thank you all very much for attending and putting up with listening to me for 45 minutes. So have a great afternoon and have an enjoyable rest of your day.